Chris Drayton and Clifton Brown were drug mules. They taped narcotics to their bodies and traveled to large towns where they could dispose of them for large profits. One such exploit, a bus trip destined for Detroit, Michigan, was spoiled in Tallahassee, Florida by 3 enterprising officers of the law. When the bus made its regularly scheduled refueling stop, the passengers were instructed to get off the vehicle so that it could be cleaned before continuing its northward journey. Once these tasks were concluded and the passengers reboarded the bus, they were joined by officers Blackburn, Hoover, and Lang of the Tallahassee PD. It seems that the Tallahassee PD had become aware of the role the bus routes through its city had played in the transportation of controlled substances. Though the officers were not in uniform and their weapons were concealed from view, they clearly displayed their badges and carried themselves with the air of police officers. Officer Hoover took up a position at the front of the bus, kneeling in the driver's seat, facing the rear of the bus. Officer Blackburn stood at the rear of the bus, facing forward. Officer Lang slowly walked down the aisle, engaging the passengers in small talk and observing their surroundings. He asked various passenger questions like, "Where are you heading to?" and asked them to point out which luggage belonged to them. At no point did any of the officers block the exit to the bus or obstruct a person's ability to move about. At no time did the officers state that people were free to leave or refuse to cooperate. The officers intended for their engagement to take a few moments to make some observations and get on with their day. When Officer Lang made progress that brought him to the row containing Christopher Drayton and Clifton Brown, he showed the two his badge and said, just loud enough for them to hear, "We're attempting to deter drugs and illegal weapons on the bus." When Officer Lang asked them to point out their luggage, they both pointed to the same green bag in the overhead luggage rack. Naturally, Officer Lang asked if he could take a closer look. Clifford Brown told him to go ahead. Officer Lang opened the bag for a quick look and didn't find anything interesting. He closed it back up and returned it to the rack. What Officer Lang did find interesting was that both Drayton and Brown were wearing heavy jackets and baggy pants. This was out of the ordinary, given the warm weather on that day. Officer Lang asked Clifton Brown, who was seated next to the window, "Do you mind if I check your person?" Brown said, "Sure," leaned forward in his seat and opened his jacket. Officer Lang felt Brown's outer clothing and immediately detected packages affixed to Brown's body. Recognizing from previous experience that this was how drug mules concealed contraband on their body, Officer Lang had Brown stand up, put handcuffs on him, and had Officer Hoover remove him from the bus. This left Officer Lang and Chris Drayton looking at one another as the other passengers surely gaped at the two. Officer Lang asked, "Do you mind if I check you?" The still seated Drayton's response was to lift his hands off of his thighs about 8 inches. Officer Lang reached down and felt similarly situated packages attached to the lower body of Drayton. He told Drayton to stand up, he handcuffed him, and removed him from the bus. The officers arrested Brown and Drayton and subsequently found 483 grams of cocaine on Brown, between several layers of boxer shorts. Drayton himself carried 295 grams in a similar fashion. By any standard, this is no small amount of controlled substance. Drayton and Brown were to be easily convicted. How could they not, given the weight of the evidence the Tallahassee PD had against them? Their best hope at avoiding paying for their crime was to raise a constitutional issue. Did they have a choice but to cooperate with the police in this matter? Maybe they were unreasonably seized by the officers because they were on a bus. You see, if they could demonstrate something like this, a court could conclude that they did not voluntarily consent to the search of their persons, and the evidence, all 778 grams of the cocaine, would be suppressed from the state's evidence. Dispensing with their inappropriate seizure argument, Justice Kennedy, who wrote for the majority in the case United States versus Drayton, stated that police officers do not seize people simply because they approach them on the street or other publicly accessible places to engage in conversation. A seizure is something more than that. To put it succinctly, Justice Kennedy wrote that if a reasonable person felt free to terminate the encounter, no seizure occurred. The officers did not brandish weapons, spoke in polite and quiet voices, and made no effort to limit the passengers' ability to move about. What about Brown and Drayton's claim that they felt they had no choice but to cooperate with the search of their persons? Justice Kennedy and the majority of the Supreme Court was equally unmoved by this claim. He reaffirmed that police officers do not need to inform persons of their right to refuse an officer's request to search. The voluntariness of any consent granted to an officer will continue to be evaluated on a case-by-case basis, based on the totality of the circumstances surrounding the exchange. So, in similar situations, officers are at least forewarned that the tone of their voice, the explanation of their conduct, the concealment of their weapons, and how they carry themselves are obvious factors a court will consider when attempting to determine if any subsequent consent obtained was voluntarily granted. And the story of the Fourth Amendment moved on. I'm Stephanie Kearney Quilling, and this has been a FLETC Talk.